duty of confidentiality if we somehow start finding exceptions for that to be disclosed.
So,
And maybe I'm wrong, but I want to study a little bit more. But are there specific exceptions that might be relevant here, Suzanne, in 1.6 or 1.9 that would apply here, that would say we can? Because I haven't heard anything that anybody's pointed to which says this rule says we can do it. I sort of hear the opposite. There's nothing in the rule which says we can't do it, and therefore we can do it. I thought I heard that. Well, where in the rule does it say that lawyer B can't do this? And because there's nothing in our rule that says a lawyer B can't do this, we on this phone are saying, well, lawyer B should be able to do it. And I'm pointing, is there something in the rule which would say lawyer B can or cannot do it?
I'm seeing something that says this is custom live streaming to a third party. I'm just jumping in. Are you guys seeing this notice that just popped? Does that matter? Maybe it doesn't.
No, it's supposed to be live stream.
Yeah, right.
I hit the wrong button. I'm sorry, I hit the wrong button, guys, but that popped up, and that's why I left.
But Todd, what if it is a non-lawyer that buys the steamer trunk full of client files? They can do whatever they want with it.
Well, maybe that's the distinction if there is, but the rule doesn't say that. That's what we're saying. But clearly we've got a situation where another lawyer has the file, and that lawyer B is bound by the same duty of confidentiality as a lawyer, as a professional that lawyer A was. Maybe that's the distinction, as the non-professional is not bound by the rules of professional conduct and the legal professionals' duties and obligations that we are, whereas the lawyer, clearly, lawyer B right here, knows that he's bound by the same duty of confidentiality, and perhaps that's why he actually reached out to us versus just saying, okay, I wasn't a lawyer before. It's just like I'm a non-professional. I'm analogous to a non-professional, and so this wasn't my client, and so I should be able to distribute this all I want. He luckily was able to bring this before us to give us an opportunity to study it. And I agree that, and maybe that might be the distinction, although I don't see anything in the rule. And to me, I'm not even sure that covers it, because to me, indefinite means indefinite, and that is the hallmark of this profession, confidentiality. And I think we guard it, sort of indefinitely as well, in my view. So if that were the difference here, that this was a non-lawyer, non-professional, perhaps, but that's not this fact situation. That is a lawyer B who is bound by the same duty that lawyer A is bound by. And we all on this phone are bound by that same duty. Now we're getting ready to say, because lawyer B, who's bound by the same duty, wasn't the lawyer for the client, he can do whatever he wants to do with this stuff. And he can violate this client's duty of confidentiality, which our rules say is indefinite and survives death. I have a problem with it. I mean, this is the committee, and we'll bring it back and we'll deal with it as always, but I'm just wondering whether the state bar is sort of blessing the disclosure, for lack of a better word, in my view, the breach of this duty of confidentiality, which our rules say is indefinite and survives this client's death. And we're getting ready to say, well, not really.
But it's indefinite to survive the client's, it's indefinite duty to the lawyer A and the client.
It doesn't say that. Our rule doesn't say that. It says the duty itself. It says the duty itself is indefinite and it survives the death. The duty.
What do the rules say though, Todd, where the duty of confidentiality arises? Don't the rules say that the duty of confidentiality arises out of the lawyer-client relationship, right?
And once it arises, it exists forever, regardless of what happens to that lawyer-client relationship. Once it arises, it exists forever and always, regardless of what happens to that original lawyer-client relationship, which is why I say it's larger, in my view, than that relationship. That duty to me, is larger than that relationship, because that all sorts of things can happen to that original lawyer-client relationship, as we know. You can get fired. Okay, if you fire the lawyer, can you then go and disclose it all? No.
So in your
I think it's I think it's larger.
And I understand that, but in your interpretation, that duty then applies to any lawyer anywhere for confidential information that arose between a client that was not that lawyer's and another lawyer. Because that's what I understand. When you apply it broadly like that, then to me, what you're saying is that a lawyer has a duty of confidentiality to any information obtained by any other lawyer in the course of their representation. And I don't read the rules like that. And I don't see, to me, and again, I'm happy if somebody will point out differently, but I don't see anything in the rule that says anything other than that the duty of confidentiality that a lawyer has to the client arises out of the professional relationship, out of the lawyer-client relationship.
Christina?
You know, I'm fascinated by all this discussion. I think you all have made really great points, and I'm completely in favor of the idea that we don't want to add a burden onto lawyers just by the fact that they're lawyers in this situation. But I feel like Todd makes some really good points as well, in the sense that, okay, it wasn't lawyer B who violated the rule by allowing this file to exist and to pass through different hands for as long as it did. That was not his violation. However, he's aware of the violation, and by sharing it, does he not perpetuate that violation? That where if because we are lawyers and we're aware of these obligations, that I guess what do we tell lawyer B in the alternative? Okay, what does he do with the file? Is he obligated to destroy it? Is he obligated to hand it over to the state bar? What's the appropriate action here? I mean, there are any level numbers, you know, there's a spectrum of what he could do here. Destroy it to publish it. So I guess, and you know, the publishing is pretty extreme, but that's because it's a matter of historical significance. I mean, I'm curious too. I mean, I'm naturally inquisitive, so I'd love to know what's in that file, but I don't know. I mean, I feel like I agree completely that whatever we decide, it needs to be very narrowly tailored to these facts. But I am troubled by the thought of perpetuating a violation of an ethical rule by another attorney.
Christina, that's an excellent point. If lawyer A violated the rules and now lawyer B is helping him do that, is he breaching a duty? That's a very good point. I am concerned that, you know, an individual lawyer, of course, has a duty to his client, but does he have a duty to all clients? I think that's where
I mean, I think we have to very narrowly tailor it regardless of which side we come down on.
It's definitely going to be narrowly tailored, and I wonder if there's anything in the preamble that would kind of talk about the overall fiduciary duty that you have as a lawyer to protect information that you know was meant to be confidential to begin with.
That's what I think we have to be careful, because our rules are meant to, and the discussion of the preamble brings it up, our rules are meant to govern people's conduct when they are acting in their capacity as an attorney. And we've stressed in the past on a number of occasions that we're not regulating your conduct when you are not acting as an attorney. And I think that's to me is the distinction that is here. If this guy were in the successful law firm, if he were representing the estate, if he were doing anything else, that's a whole different matter. But he's not acting as a lawyer in this capacity, and therefore his professional conduct. And if you guys think back to the discussions that we had about the preamble, it was that these were aspirational goals, first of all, but they were also goals that but they would not regulate conduct of folks when they were not acting as in the capacity of an attorney. And so I think I see that as a distinction here. This guy is in essence a foreigner to the whole business. He just happens to be an inheritor who is a lawyer. And as I say, I'm prepared and comfortable with us doing something, taking some sort of a page out of the legislature's book and saying, if this happens to you, you should contact the state bar just like you, or because you're acting as a non-lawyer. Then you are an inheritor. You're not acting in the capacity of lawyer coming into possession of this file, and therefore you should turn it over to the state bar within 15 days and don't do anything with it until the state bar takes possession of it. That gives us a way to handle the situation, and I think and do what we want to do here.
Hey, David, I want to point this out because I recently, having done the Distinguished Service Award presentation, I have spent some time with the preamble. And I think the preamble actually addresses us in two capacities. It addresses us when we're acting as a lawyer,
Yep.
but it also addresses us acting as a citizen.
Mhm.
So it does because of our special privilege as a lawyer. It imposes the preamble aspirationally other duties on us in our citizen capacity as well. So I think that I wanted the group to realize that. The other thing I'm sitting here thinking, do we do violence to our existing rules over one matter that is never likely to be repeated in our lifetime? This is something that happened back in 1930s.
That's 100
And
years
here
ago.
we are 100 years later addressing it, and we're getting ready to maybe alter, modify our rules for something that happens maybe once in 100 years. That bothers me. I don't like extreme examples being used to change slightly or drastically our existing laws. I'd rather for there to be sort of a large volume of instances, occurrences, something in society that compels us to revise, ignore, look the other way for our rules, if that's what we're thinking about doing. So I want the group to think about this as well, and because I don't like to change things drastically for one matter, and this is one matter that probably we will never address in our lifetimes. So think about those two or three things, please.
Todd, I agree with you. I wouldn't want to do that either, but I think to reach your conclusion, we would have to, because you're broadening a duty that's not there.
I respectfully disagree, Judge. I just don't think that's how I read the duty of confidentiality and how it applies and whether it should be overturned. I mean, one example, one view might be that, like I said, what our rules apparently say, that duty exists forever and always.
I will say, Todd, that as you said, the preamble is both regulates conduct and also is an aspirational goal. And we've been out of our way to say that we would never have discipline for folks based on something in the preamble. And what I'm saying is that if we were wearing our grievance hats and this guy had given this material to the Ronaldo House to publish, I believe we'd have a situation where Carmen would be coming to the ethics committee to say, like she did with the pictures a couple of years ago and with other places, where we're not going to discipline somebody if there's not a rule that says you can do it, or even relying on the comment. And I think here, if we were doing this from a grievance perspective and doing that analysis, there wouldn't be discipline imposed on this guy here. And that's a perspective that I think we ought to at least think about, because I think that's always a helpful analysis to go into, is if this were a grievance, would we in fact be imposing discipline on this guy for doing it? And I don't think any of us would impose discipline on it here.
I agree with you, David. If that were the case, I don't also like making decisions based on hypotheticals. That's a hypothetical. There's not a grievance issue here. And luckily, this lawyer B brought this to our attention and gave us the opportunity to make sure it never becomes a grievance issue. So that I respect your hypothetical. I just don't like making decisions based on hypotheticals that really when are contrary to the true facts before this committee right now.
I don't know what facts are not true in my hypothetical, but
I'm saying hypothetical is correct, but I'm saying that's not this situation because lawyer B brought it to us. There's no grievance involved.
right.
I do think it was interesting also that lawyer B did not feel comfortable just doing it. I mean, he obviously felt like there was some issue as to whether it was allowed or he wouldn't have called in the first place.
I think that's right.
I think that's right.
This is I've set my position. This is the committee's call, and so I just wanted to make sure that I was and Suzanne will know. And I don't get on here to try to dominate. I try to get on here to try to give the opposite side of an issue, and that's all I've tried to do here. But this is I am a huge believer in majority rules. It's exactly how it works. It's exactly how it works.
When we go back to the full committee, there are a lot of counselors who believe like Todd does, because we heard from them at the last meeting. So we have to be prepared if this is our consensus as a committee to sell this to the body. I think we're going to be pretty split down the middle.
And Tom, if you remember, I was one of those who was on the other camp of this thing when we had this discussion initially in January about what we ought to do with this thing. But in looking at it, I mean, I'm just having trouble finding the cubbyhole we used to say no.
Christina?
Another thought that triggered was, does Rule 8.3 have any bearing on this? Because we are obligated to report a violation of another attorney. And I guess, I mean, certainly I don't feel like that's relevant here in the sense that lawyer A is deceased. But I wonder if maybe, and I just pulled it up on my screen just to look briefly, and I don't see anything that jumps out at me as helpful in this situation, but I wonder if that's something that we should consider as well.
I mean, 8.3, not every violation of the rule has to be reported under 8.3. It has to be something that, I forget what the words are, rises to the level of
Raises a substantial question
and fitness
as to
to
that
practice.
lawyer's honesty, trustworthy, or fitness. Okay. Yeah, and I don't see that thought rising to that level.
Yeah, maybe not.
Okay.
Okay, so it seems like we have a draft of an opinion going one way. Let me draft an opinion going the other way. So what I would like are points from you guys on what to base it on. And I think the biggest ones are there's no attorney-client relationship. And what else did you guys? Information learned during the representation, no attorney-client relationship. Were there other?
Well, I think it's worth noting that the sale of a practice has a rule for it, and the landlord's obligation duty has a statute carved out for it. So there's
the duty of the original lawyer, the lawyer A, in handling client files or making provisions for client files upon their death or close down of their practice, retirement, whatever.
Okay.
any language in the preamble that you want to?
Yeah, I mean, David and Todd are both, I mean, I'll look at it, but it's not really enforceable. I threw that out there, but the more I think about it,
But if this is going to be a letter to this guy, and to Todd's point about like the look of it all, I mean, is there a way potentially to bring something in about the preamble and say, well, we discourage the revealing, does it specifically does it violate a specific rule of ethics? I mean, maybe that's a way to distinguish this, because I think I disagree with Todd. I personally think that the duty applies between an attorney and their client, not all attorneys for any information from any client. So maybe that's a way to bring the preamble in.
But I do feel like there's I mean, I agree with all that, but it does seem there are circumstances where a lawyer accepts somebody else's files and takes on the duty to safeguard the confidential information in that. I mean, do y'all disagree with that?
No, I think you're absolutely right about that, Suzanne. And I think there's the sections in the rules about safeguarding, like on the sale of a practice. I think you mentioned those in some of the other. I think that's maybe why it feels not great, even though it doesn't violate a specific rule.
Because I mean, he did accept, I mean, yeah, I mean, it's just a gray area to me, because did they just keep that file because it was, family history, or did mom give it to him and say, you're a lawyer,
Right.
I need you to keep your dad's client file confidential?
Yeah, I think to me, there's no question if the arrangement that lawyer A had made was to pass on his practice and or his client files to lawyer B, who's the son,
Yeah.
that provision of the rules would apply, and he absolutely would have a duty. But at least as I understand the facts of this, that's not what happened, right?
It's not. No, it's not. But what if lawyer A just screwed up, like we said, and wife finds the file and gives it to attorney B because he's a lawyer and she thinks he'll know what the proper thing to do with it is?
I think if Mrs. Liipfert, the wife of lawyer A, had given the file to Tom, that's vastly different than giving it to her son, because we don't know the capacity, at least I don't have it for the facts, the capacity in which she gave it to him. Was it like, this is your father's desk, and we think, or this is your father's law books, which would be something that was part of, a son lawyer maybe taking on some of his father's relics, or whether she said, you're a lawyer, you will know what to do with this file. If that last statement was what was said, then I think the answer to this is a definite, you cannot do anything with this letter. And with this file, we just don't know that answer. I think that the facts of this one are so unique.
But
I thought it was Anna on that earlier comment where it's just like, we write a 2-sentence letter to this guy and don't, and just say, this has never happened before. We don't think that, we think your initial gut to call us is right. You don't have, if the hairs on the back of your neck don't feel like you should do this, then don't. And by the way, here's the statute which says, if you were a landlord and came into possession of this, you got to give it to the state bar, and hope that he follows that admonition and turns it over to the state bar.
But when I was just listening to what you said, you were comparing a client file to a desk. And to me, that's a very different.
Well, that's what I'm saying, Suzanne, we don't know the capacity in which the mom looked at it. If she was just giving her son a bunch of stuff from his father's office, and one of them was this file, that's one thing. To your hypothetical, if she said, you're a lawyer, you will know what to do, that's the same as if she's giving it to Tom, in my view, because now she is triggering his professional capacity as opposed to his familial capacity. Mm-hmm. That's what I think triggers the responsibility here.
And Mr. Liipfert may know the answer to that.
He said, I mean, I don't think it's as clear. I think she just gave it to him, but I'm not sure. I mean, he is a lawyer. I mean, to me, that's what it comes back. He got it. He is a lawyer. It's not, he got his dad's desk. It's a desk. I can use this desk. I can do whatever I want to with this desk. Then there's this client file. This is a client file. I can't do whatever I want with this. It's just very different to me. But there we are. I will take a crack at writing it based on lack of an attorney-client relationship. Is that what you want me to work on, guys and gals?
I mean, we've got two differing opinions, so I think we should have two differing drafts out there for the larger committee to review and tweak. Because I think we're going to get, we may all agree here with the exception of Todd, but I think you're going to get some pushback.
No, I think that, I mean, more, sometimes, you know, the more we're talking about some things were bothering me again. But I am going, I mean, maybe the best thing is just to say to Mr. Liipfert, there's no rule against it, period.
Yep.
Which I think is true, and it's not necessarily a lesson.
I see Todd.
I'm not sure I agree with that, and I've already said my piece on that.
Gotcha.
And just for the record, we're not talking about a rule violation. Nobody suggested that at all, right? We're not talking whether a rule has been violated by lawyer B or lawyer A, have we? Are we?
We're preventing a rule violation is what we're trying to do. He is asking us if
Yeah,
I
right.
give this file away, have I violated some rule
That's
profession?
right. Okay.
Does that make a difference?
No, I just thought a lot of the discussion dealt with whether a rule had been violated or not, and I don't see that as, again, I just see it as our analysis, opinions, opining on what is meant by the duty of confidentiality. And when does it cease to exist, if it ceased to exist, and if it ceases to exist, under what circumstances? And does it cease to exist under the circumstance here? Or does it continue forever and always as our rules and comments seem to say? And I know others disagree. I know others disagree with that.
But I think anybody that was at the meeting knows that there was a lot of discussion both ways. So
That's right.
Christina, I'm sorry.
I think I'm probably the one who started talking about a rule violation by lawyer A for failure to safeguard or properly dispose of the file, because if that had been done, this would not be an issue. So I'm the one probably who raised that. And then I could be convinced that it's not, but it looked like that to me.
I mean, I think that was a rule violation, not necessarily a reportable one.
Yeah. And he's
Right.
dead now.
And certainly don't want to besmirch the name of someone who's no longer.
Right.
But
and I don't know what the rule was when he died. It could have been a different rule.
Right.
that's true.
That's right. Yeah.
The fact that we're doing an RPC on this for guidance.
That is a very good point. That is a very good point.
Suzanne, I do want to ask.
Old law is good law. I'm a believer in that.
Yeah, and law at the time matters. Suzanne, I do want to ask this question in light of what Tom suggested. Are there times when we submit two competing opinions and then the full committee chooses which is which?
Yep.
That's the exception than the rule, though, right? Typically, we try to avoid that.
Typically, we try to avoid it,
Okay.
but sometimes we can't, and then sometimes we won't get sometimes we don't get a consensus, and then we don't do anything.
Right, I got
and
it.
tell the lawyer we couldn't get a consensus.
Okay.
And then usually there's a cage fight between me and Nicole and Brian, and then maybe there's a dance off, and ultimately we just, but no,
So-
it's
So long
fine.
as there's no cage fight between David Allen and I, then that's good. I don't want any part of that. I don't want to be on the losing end of that.
I did. For those of you who know him, I will tell you that I was accused a couple of years ago. I had a case with Kirk Warner from Smith and Anderson, who's a big figure in the law.
That's right. That's
and,
right.
The judge said, "I'm not quite prepared to have a sumo match between Mr. Allen and Mr. Warner."
He's military too, right?
Mhm.
I think that's right. Yeah.
Chief. So that's the difference. See, he's military. I also chief. So what other? We're going to have alternates. We also might just include the letter that Suzanne just mentioned, which is, because I think that's ultimately what the committee is going to want to do, is to send them a letter that says, we're not going to publish on this, and we're not going to have any. There's not going to be any sort of precedential effect. That's also the other nice thing about a letter ruling, is that there's not a precedential effect there. And so we might have that, Suzanne, just as a thought, to have that as I think that's the easy way out for the committee, rather than go down the other road.
And I think because this is 100 years old and it's probably not going to impact anybody's life, that the one-off works. It's no harm, no foul. But certainly a lot of important issues are raised by it. A lot of things to consider, just how we address confidentiality going forward.
I don't like the fact that you keep saying 1930 was 100 years ago. That's also bothering me.
It's close.
Pretty close.
It might be 100 years before we actually finalize this. I do think that the full committee will probably be close to evenly split from what I could
It'll be
see
close.
and some great points have been made by both sides. Todd, of course, a very strong moral argument, and Christina perpetuating the other lawyers' lapse is certainly gave me a lot of food for thought.
Well, I'll work on another opinion, and if anybody wants to send me any suggested anything they would like to see included, and sometimes when I start working on one from the opposite side, it makes something clearer that wasn't, clear before. Sometimes it doesn't. I don't know that we'll be able to meet, or I don't know what you want to plan as far as future activities of the subcommittee, Judge.
I think, after the April meeting, we'll see where we are and schedule something after that.
Just tell them we're still working on it.
Yeah, and get some thought on what their opinions are at the next meeting. Maybe that's something we can incorporate.
But do we need to report that we didn't have consensus, or that we did think? I don't know how that works.
Just report what happened.
Yeah, just report what happened. I mean, I think we have consensus, but
I think we do too, but I just didn't know if it needed to be formal or.
What is the consensus that we have?
That's what I mean. I didn't know if we needed to have a vote or just submit the two and then let the whole ethics committee debate it again. I just don't know what the process and procedure is. Sorry, I'm new.
the committee has to adopt our recommendation either way, right? They can shoot it down.
I think that at this point, what you would say is that we're still working on it.
Yeah.
That we had over an hour-long meeting. We talked about, we'll include that draft of the opinion in the agendas. We discussed that draft. Did not agree on that draft. Want to look at it from, the other angle, and maybe consider, some in-between options. Is that what everybody's thinking?
Yes.
Not with me.
Yep. Sounds good.
I would just want to throw in real quick. This is when I was trying to do some research. I got off on a tangent of historical value of client files, and there are ethics opinions that talk about the fact that just because something is of great historical value, that is not an exception to Rule 1.6. When there's a, clearly a 1.6 or 1.9 relationship, the fact that it's historically really important doesn't matter. Which I was a little bit surprised that it was so clearly not an exception.
Got it. Okay.
I mean, this one is not quite as historically valuable as some of the other things.
Curiosity killed the cat, right?
Yeah, that's right. That's right. Well, thank you all for great work as always. I'm always fascinated by how great a job you guys do. So thank you for letting me participate. And again, I'm just one voice. Democracy rules here. Great work.
And also, let me just say real quick that Todd's DSA presentation for Ted Edwards was so good. It was so good. It was fantastic.
Well, thank you.
And
He
Ted's-
deserved it.
He did, and he spoke, and it was just wonderful.
It was amazing.
That's the question that he's saying.
He didn't.
Ted has a gorgeous singing voice, and
He's like a jack of all trades.
It really is. Yeah.
But
Yeah.
it was just really good.
Amazing. Yeah.
It was well done all around. It was great. He and his family were very happy, and that's the main thing.
Yes. All righty.
Suzanne, if we want to email you anything, do we have to copy everybody on the
No,
committee?
you're not supposed to copy everybody. You're
Awesome.
supposed to only copy me.
Okay.
If you want to say ugly things about me, Judge, please don't CC me on it as well.
I'll just text you.
And Suzanne will not share it with me, trust me.
Well, I'm sorry that we couldn't make this easier, but it's not meant to be, I guess.
Thanks.
All right. Well, thank y'all. Enjoyed it. We'll see you in April.
Thanks,
Thank
guys.
you.
Bye-bye.
Bye.